I'm not your bro. I'm not your man, and I'm not to be interrupted when I'm speaking. Just because you're unsatisfied with the way that I ruled, then that's not my problem. City of Detroit versus Christopher Perry Lewis. Case number SP 151-06611. Appearance for the record, please.
Sherika Harris on behalf of Mr. Lewis, please state your name for the record.
I don't have an attorney. I'm representing myself. I articulated that at the last hearing.
Today is the date and time set for a ring on the bench warrant. I'm going to enter not guilty plea on his behalf. I'm going to give him a $0 bond. Mr. Lewis, you said you were here last time. Why did you miss your date?
I actually didn't miss the date. I actually sent you a motion today to show you proof that I was actually in the hearing, and I was locked out of the hearing after an hour of waiting. As well as I sent you a motion for dismissal as well. I sent it last week. Yes, I sent it last week, but I resent it today, and I sent it in a Zoom chat as well to the prosecutor, the clerk, reporter, as well as the clerk.
I didn't get that motion, either of those motions.
All right, guys, strap in. Today's courtroom drama kicks off with Judge Perkins making it crystal clear. He's not your bro, not your man, and definitely not to be interrupted. We're heading straight into the city of Detroit versus Christopher Lewis, a self-proclaimed legal wizard who thinks he knows more than every lawyer and judge alive. From the moment the gavel hits, you can feel the tension. This isn't just another routine arraignment. It's the opening round of a verbal cage match where logic meets pure stubbornness.
Is there any way you have availability to look at the Zoom message, right? I sent it to not only your email, but the Zoom chat as well.
I need it in my email. I don't
sent it twice. I can tell you my email if you want to search it, but you should have it twice in your email. I resent it.
What's your email?
Chris, CHRISLEWIE, Midtown, that's MIDTOWN @gmail.
Chris CHRISL, right?
Yes, EWIE.
I don't have it.
Okay, I'm resending it at the moment.
I'm gonna put my email address in the chat and put my email so you'll have it, and send that to me, and we will have an opportunity to read that. I'll confirm that you sent. I'll wait to confirm that you sent it to me, and I'll give you a date. The next court date is going to be a pretrial date on May the 28th, 2024 at 8:30. You need to get a copy of that to the city attorney as well.
I actually just sent it to the prosecutor as well. Daya Mason, is that her?
Yes.
Prosecutor? Yes, I did just send her attachment if she could send.
Lewis strolls in, announcing he's representing himself because, of course, attorneys are unnecessary. He claims he sent motions to dismiss and insists the court just missed them. Judge Perkins patiently explains he hasn't received anything, while Lewis argues about emails, Zoom chats, and missing paperwork. Listen up. This is classic sovereign citizen chaos. The man is sure the system is broken simply because it won't bend to him. Already, you can sense Perkins keeping his cool while Lewis ramps up the theatrics.
A confirmation that she received it.
Oh, get it to her email address. So Mrs. Mason, you put your email address in the chat as well, so Mr. Lewis can get you a copy of that.
I really appreciate that.
File of that motion, those motions. All right. I'm gonna wait on that. Once I confirm that you gave me that, I will recall the case. On the record with Mr. Christopher Lewis. I have received this motion, and I read the first couple of lines of it, and that I'm not concerned necessarily about the March 18th incident. I don't know what happened on that day, but you are here now, so we'll move forward.
Excuse me, sir. I heard you say that you only read the first couple lines. Is there any way we could possibly take another case until you get the chance to read the entire thing? It's only 2 pages.
I'm not going to read this entire thing today.
It's only.
After a comedy of errors with email addresses, The motion finally lands in the judge's inbox. Perkins glances at a few lines and, bam, dismisses it. Cue the fireworks. Lewis demands a full reading, insists on written explanations, and starts citing constitutional amendments like a late-night Google scholar. But Perkins isn't buying it. He's seen this routine before and shuts it down with steady authority. The tension rises as Lewis keeps pushing, demanding venue changes and claiming his Fourth Amendment rights were violated.
The entire thing. The rest are just case sightings.
All right, I'm gonna deny the motion. I will set the matter for
Is there any way I can
trial.
get a written? Can I get a written articulation as to why you're denying the motion?
I'm denying the motion,
I would just appreciate
because
a written excuse. Can I get a written articulation?
I'm not give it to you in writing.
Are we on record? Are we on record?
We're on record.
Okay. Is this court bound by the U.S. Constitution and Supreme Court rulings?
Yes.
Okay, you were denying my motion when I said that I had Fourth Amendment violations, and you're saying that you're denying my motion without looking into it or granting me a hearing to go over my motion, or give me an articulation as to why, a written excuse as to why. I want to make sure that that's what you're saying to me.
You're asking for a change of venue. I'm denying.
I'm saying that no, there's a motion for dismissal, and I'm saying that you, as an Article 1 judge under the Commerce Clause, if you're not going to uphold my due process and my Fourth Amendment, I'm saying that maybe we could change venues where I could get a real judge.
Now the gloves come off. Lewis insists the court is Article 1 under the Commerce Clause and calls the charge fraudulent. He wants the case moved to a real judge, as if Perkins is a hologram. All right, guys, here's the kicker. Perkins calmly denies every motion and sets a trial date. Lewis fumes, repeating demands for written excuses like they're magic words. The judge remains unshaken, a rock against a storm of pseudo-legal buzzwords and conspiracy-flavored arguments.
Okay, I'm denying the motion to dismiss, okay? I'll set a trial date for you so you can be heard on that type of form.
I insist that the court give me a written excuse as to why you're denying my motion so I could take that to the tenor, okay?
Well, you can insist all you want to.
Okay,
You get a
I appreciate that. But I'm telling you, you're telling me today why you're not gonna look into it or give me a hearing, that's so I can go over the evidence that I have to present to go with my motion. You don't want to do any of that. So I'm just asking that you can give me a written excuse that I could go take and complain against you on. Because that's violating my due process. You didn't even give me the chance to say we're going to schedule a evidentiary hearing or something like that. You're going to sit up here and disregard that when I made genuine claims and put genuine evidence in there. Overwhelming. Today, like I said, there's no crime. This is a fraudulent charge. There's no suspect. Y'all suspect me for no crime. There's no victim, no loss. Okay? And in a minute, it's going to be malicious prosecution. So I'm asking you to dismiss this charge or change the venue. And if you refuse to do that, I'm asking you for a written excuse so I can take it to the tenor, sir. That's what I'm telling you.
Lewis doubles down, accusing the court of bias, conflict of interest, and making money off him. He rattles off claims of malicious prosecution and no injured party. The greatest hits of sovereign citizen rhetoric. Perkins, unfazed, reminds him he'll have a jury trial where he can present whatever proof he thinks he has. Listen closely. This is the moment where fantasy collides with reality. Lewis wants instant victory. The judge offers the only real path, due process.
Because if not, I'm going to go to the tenor without it and let them know that you refuse to give me a written excuse and you refuse to give me an evidentiary hearing, but you just straight denied it. When you just 5 minutes ago, you said you didn't even read it. Now you just denied it. That's conflict of interest. That's bias. That's all that. So let's put it all on record. If you feel just as strongly as you feel, give me a written excuse. If not, let's change venue. Because you're an Article 1 judge under the Commerce Clause. This conflict of interest, you only here to make money, man. You know what I'm saying? It ain't no crime.
Wait a minute.
Ain't no victim or no
man.
loss, bro.
I'm not your, listen, I'm not your man.
Look, sir. Hey, sir,
Okay.
respectfully, you're an Article 1 judge under the Commerce Clause. You've been on the bench since what, 21? Couple years? You need to talk to some, asking you to give me an evidentiary hearing to go over my motion for dismissal with the overwhelming evidence or change venue. Because if not, I'm going straight to the tenor right after this. And that's on you, sir. You had this. You did this.
Oh, all right. Now I'll let you speak.
Straight like that.
No, That's all we need. I don't want to hear any
All
more
right,
from
cool.
you.
It's cool.
You made
I'm not.
The back and forth turns almost comedic. Lewis interrupts. Perkins warns. I'm not your bro. I'm not your man. The judge snaps, laying down courtroom law with sharp precision. The gallery can practically feel the gavel's weight. Lewis keeps demanding an evidentiary hearing, but every sentence digs him deeper. This isn't a debate club. It's a courtroom. Perkins sets a jury trial date, giving Lewis exactly what the Constitution provides, and nothing more.
I appreciate it.
No,
This is
don't
due
interrupt
process.
me.
This
I
is a
didn't
due
interrupt
process
you.
violation. This is a due process violation right now. And the way y'all tried to railroad me when I was ready to argue my trial. I told you I was here to argue my trial. Y'all locked me out. Now you're trying to start the process over. They not prepared to present a case. I'm telling you. They're not prepared to present an injured party. So what we doing?
Listen. Please do not say any more. You've already made your record. I've given you that opportunity. If you continue on, especially interrupting me while I'm talking, because I didn't interrupt you while you were talking. I'm not your bro, I'm not your man, and I'm not to be interrupted when I'm speaking. I gave you the respect and the right to speak. Just because you're unsatisfied with the way that I ruled, then that's not my problem. You take whatever. Wait a minute. Let me say it. You take whatever recourse that you feel that is necessary. Now, what I can do, Mr. Lewis, is I can set you a jury trial date. And at that jury trial date, you will have an opportunity to represent yourself or do whatever you want to do and put all your proofs on the record by a jury of your peers, and you can argue it.
Perkins explains patiently. If Lewis claims no crime occurred, a jury can decide. But Lewis isn't satisfied. He cries process violation, insists on a written denial, and paints himself as a victim of a grand legal conspiracy. All right, folks, here's reality. Courts run on facts, not feelings. Perkins repeats that Lewis can argue everything at trial. The judge's calm contrasts perfectly with Lewis's escalating frustration, turning the hearing into a masterclass in judicial patience.
Like a written.
You order the transcript. You order the transcript. It's in the transcript. You asked me to read the couple of paragraphs that you made. Most of the paragraphs was referencing the incident on March 18th, as you and I'm not even debating or disputing it. I said I'm not concerned about March 18th or any missed date. I said that the most of what you're saying is in the it's not I'm not even going to hold you to that, but in paragraph 2. I want to emphasize that the initial charge against me in this court is fraudulent. I don't know that to be the case. That's why I'm giving you an opportunity to have a jury trial, and they can make the determination. Neither the complaining witness or the prosecution is prepared at any point of this case to present an injured party or any reported damages / losses. So it becomes abundantly clear that every proceeding taking place is strictly an attempt to seek funds where there is no crime and not seek real justice. So
Lewis accuses officers of illegal searches and assaults, demanding immediate dismissal. Perkins stays steady, pointing out that a trial is the proper place for those claims. Lewis then dives into constitutional amendments, citing random cases like a human law library roulette wheel. But facts matter. Perkins clarifies the difference between federal and state jurisdiction, quietly dismantling Lewis's Article I judge fantasy. The judge's composed explanations highlight just how thin Lewis's arguments really are.
I'm giving you real justice because if you say that there's been no crime, then you have a right to a trial, and that's what I'm giving you. So I was assaulted, detained, and my property illegally searched and seized with no suspicion of crime at the hands of the complaining witness, Joshua Martin, and assisting officers. I do not consent to these fraudulent proceedings and demand that the court dismiss the charge immediately with the appropriate remedies. And I'm dismissing the motion based on that, because I am giving you a proper forum to argue your case, or allow me the right to change the proper venue of federal court where my U.S. constitutional rights will be upheld and not disregarded by Article 1 judge under the Commerce Clause. I don't understand that in case. He did cite some case law. It was at Sherrar v. Cullen, 481 Federal 2nd 945. For a crime to exist, there must be an injured party, corpus delicti. There can be no sanction or penalty imposed on one because of the U.S. constitutional right. Louisville versus Motley, 211 U.S. 149, South 29 S period court CT 42. Any tribunal court finds absence of proof of jurisdiction over a person or subject matter, the case must be dismissed. The accuser bears the burden of proof beyond a reasonable doubt. All right, so I'm dismissing the motion, all right? And you can get a copy of that record on of what we just made by going through the proper channels of the court to get the court reporter to produce that record.
I can't even get the court reporter to respond to my voice messages or you to respond to my emails, sir.
The court reporter is not going to respond to your voice message. The court reporter is going to respond to you
The
coming down.
36th district told me to call her today, that I was locked out of my trial date. I had a scheduled trial. The court told me to call her that day, and I called her that day, and she still hasn't responded. So I'm trying to see if the court that you work for is trying to tell me how.
When Lewis declares the entire proceeding fraudulent, Perkins simply grants him what he's entitled to: a jury trial. No drama, no shouting, just the rule of law. Listen up, guys. This is how real justice works. It's not about who yells loudest. It's about evidence and procedure. Lewis keeps throwing legal spaghetti at the wall, but nothing sticks. The court remains unshaken, a monument to the boring but essential process of actual justice.
The appropriate channels, and then y'all doing it different in y'all court. What am I to do?
I think you're talking about the court clerk and not the court reporter. This is a distinct.
Yeah, I was told to call the clerk the day that I was locked out, the moment I was locked out.
So we've moved past that getting locked out.
But that was my trial date.
Yeah, so I'm giving you
How soon can I get another trial date, sir? How soon can I get another trial date? That's what I'm asking.
That's what we're trying to do now.
A jury trial.
A jury trial. I'm gonna let the jury of his peers hear what he has for at 9 a.m.
July 23rd?
Yeah, 2024 at 9 a.m. We'll have a final pretrial the day before.
Why would we need a final pretrial? Why would we need a final pretrial?
Because I said I wanted one.
But that's how you protecting your interest. You protecting your interest, and you're gonna dismiss it on that day. So you trying to play with me? You could dismiss it today, sir. You literally, but
a final pretrial 8:30.
You are literally violating my due process. You can't even give me a written excuse, but you want all this whole.
Mr. Lewis, I know you don't want counsel, but is it possible we could talk in a breakout?
Excuse me, ma'am. I do. Excuse me, ma'am.
The judge patiently sets dates: July 23rd for a final pretrial and a jury trial the following day. Lewis complains, suspects a setup, and insists the judge is protecting his own interests. Perkins doesn't flinch. All right, guys, respect where it's due. The judge keeps it professional while Lewis spirals. The contrast is striking. Calm authority versus frantic accusations. It's the sound of a legal system quietly doing its job.
I am in pro se.
Go to judicial tenure, go wherever you want to. Final pretrial of July 22nd, and trial date is going to be July 23rd. All the parties must appear on the final pretrial date, and the jury, and that can be on Zoom. And the next day, the jury trial date is in person. Have a very room, please.
As the hearing winds down, Lewis still argues about clerks, emails, and missed messages. He wants faster dates, more explanations, and of course, a written excuse. Perkins, cool as ever, repeats the schedule and moves on. This is Courtroom Reality, check 101. No amount of ranting changes the calendar or the facts. The judge is given every opportunity for fairness, and that's the final word, whether Lewis accepts it or not. All right, guys, that's the show. Judge Perkins wraps it up, wishing everyone a good day. Lewis corrects the judge on his name, but the hearing is over. The gavel falls and the lesson stands. Sovereign citizen theatrics might create viral moments, but they won't beat the law. So hit that like button, drop a comment with your favorite jaw drop moment, and subscribe for more courtroom chaos. Because when pseudo law meets real law, you already know who's walking out the winner.